On January 31st, 2023, the Bureau of Alcohol, Tobacco, Firearms, and Explosives published their final pistol brace rule on the Federal Register, thereby enacting it into effect. The rule was a complete reversal of two prior rulings that the ATF made more than a decade earlier in 2012 and 2014. In those rulings, the ATF clearly stated that individuals who purchased a device known as a pistol brace and attached it to a pistol were acting within the law, regardless of whether or not it was fired from the shoulder, as one would a rifle, or one-handed as the devices were originally intended. Specifically, they ruled that doing so would not turn the pistol into an SBR or short-barreled rifle. The new ruling from the ATF now says that attaching the devices to pistols is a felony, punishable by up to 10 years in prison per attached device. The reason? Now they've decided that doing so turns it into a short-barreled rifle. The Congressional Research Office estimates that there may be as many as 40 million devices now in circulation, resulting in a constitutionality crisis manufactured by the ATF by moving the goalposts on millions of Americans. There are no provisions for grandfathering, and many Americans in many states have no options other to effectively destroy their devices or turn them in. The same day that the ATF published the rule, the Wisconsin Institute for Law and Liberty, a nonprofit individual rights and liberty-based law firm, sued the ATF over their decision, asking for injunctive relief to block the rule from going into effect, as well as for a court declaration that the entire rule was illegal based on multiple different theories of case. On February 15th, 2023, I was privileged to sit down with one of the lead attorneys, Lucas Weber, from the Institute for Law and Liberty, to discuss the case, the issues raised, timelines and possibilities of injunctive relief, and a whole lot more. If you want to support the Institute for Law and Liberty, there is a link in the description box below. If you don't have a few dollars to chip in, I get it. Keep in mind that liking the video, sharing it on social media will all help to get their message out there, as well as commenting your support as well. Of course, on a more selfish note, subscribing to our channel helps us get more interviews like this one. Thank you very much. Attorney Lucas Weber, welcome.
Hey, thanks, Tom. Thanks for having me.
Thanks for coming in. So you know why you're in here today, but the folks down the lens maybe have a little bit less of an idea. What's going on?
So a couple of weeks ago, the federal government promulgated a new rule purporting to reclassify every pistol that has a stabilizing brace on it as a short-barreled rifle under federal law. This has significant regulatory ramifications for everyday Americans. Up to 40 million Americans. Their estimates about 40 million that could be impacted by this. It's a tremendous change and something that most people aren't even aware of.
And when you say regulatory impact, I think you're being very charitable. Because what you call regulatory impact as a civil law attorney, I call 10 years prison.
Yeah, exactly. I was perhaps being significantly overly charitable there. But yeah, overnight, what this rule does is it reclassifies these firearms as NFA firearms, which means the possession of it, the unlicensed possession of one, is a felony, punishable by a fine of up to $10,000 and prison of up to 10 years or both.
And let's just kind of quickly set the stage before we get into the meat of this, in case people are just kind of coming down the funnel here. So are you able to register an SBR in every single state? Is an SBR lawful in every state, or does it only work for certain folks in certain states?
So states do regulate them separately. I don't know the individual laws in every single state, but states do regulate SBRs on their own as well. At the federal level, the federal government requires a tax stamp, a $200 stamp purchase before you can lawfully own an NFA firearm. It also has to be registered in their federal database. And then once you have it, ATF takes the position that only you can fire that firearm. So as the registered owner. So if somebody else wants to shoot your gun, they can't if it's an NFA firearm.
So of course, you know, many folks in many different states have no ability to register under this because it's illegal to register. I mean, certain states just non-starter. New York, Illinois, California, New Jersey, just to name a handful. So folks who have these stabilizing braces in these states, which were purchased lawfully, they have no options here. I mean, they just have to throw it out. Is that right?
Yeah, that's correct. And in many cases, they purchased them lawfully. They purchased them with ATF's explicit blessing that these were not SBRs when they were purchased as determined under federal law.
Yeah, and of course, a short barrel rifle, for those of you who don't know, we're talking about a rifle that's designed to be fired from the shoulder. It has to have two further criteria. One is has to have a greater overall length than 26 inches, so 26 inches and up, and it also has to have a 16-inch barrel. And of course, there's details about having pinned muzzle devices, and of course, check your local listings, because I know that there's possibilities that there's some states out there that may change their overall length from 26 to 29 inches and all that kind of stuff. So check your local listings, take responsibility for knowing what you're talking about here. But so what has your group, and what group are you part of, by the way?
So I'm an attorney with the Wisconsin Institute for Law and Liberty. We're a public interest law and policy center based out of Milwaukee, Wisconsin.
And what kind of work do you guys do?
So we bring cases to support our mission. Our mission is to advance the public interest in the rule of law, constitutional government, individual rights. Wherever government is overreaching and it's to the detriment of everyday citizens, Will wants to be there to bring that fight to the government.
And this is obviously really important. So we're going to put a link in the description box below if you want to get involved with helping them out, because obviously as a nonprofit, you're always looking for help. And my understanding, correct me if I'm wrong, but you guys generally, if ever, charge your clients. I mean, you're basically not for profit. You're free because you're interested in just advocating issues.
Yep, we do not charge our clients a dime for our legal services. We bring these cases. We front all the costs on them. Sometimes at the end, we're able to recover our fees depending on the individual suit. If there's a statute that allows us to, we love to do that. But our clients, they're the brave ones who step up and put their names on the line, put their face associated with these suits. We don't charge them a dime to do that.
So you guys, of course, are representing a handful of people now. You're suing the Biden administration. Who else are you suing about the pistol braces?
So we've just named ATF as our defendants.
Okay.
We have three plaintiffs. They're all veterans who have stood up, taken an oath to defend our Constitution, to defend our country. And they're all now standing up to fight back against this unlawful regulation that ATF put out.
And what specifically is your lawsuit saying that they got wrong, they being the ATF? What kind of remedies you're looking for, just that kind of stuff?
Yeah, so the remedy we're looking for is just to have the rule completely set aside, right? So the federal law allows us, if a regulation is unlawful, it can be set aside. So that's what we're asking the court to do. The reason that we're able to argue that it's unlawful, we make constitutional arguments. So first, this regulation infringes on the Second Amendment rights of our plaintiffs. And secondarily, the rule amounts to lawmaking. It violates the constitutional separation of powers, because here you've got federal bureaucrats who are unelected, are not members of Congress, who have essentially rewritten a federal law. Beyond those constitutional claims, we also have statutory arguments under the Federal Administrative Procedures Act. We make statutory claims. For example, when a federal agency decides to change its mind on how it's regulated something for a period of time and change its mind, there's certain things they have to do. One of those things is just acknowledge that they're actually changing their mind. Here, ATF doesn't really do that. In their rule, they go out of their way to say, no, there's a lot of uncertainty. There hasn't been a clear rule that's been in place for 10 years, and this rule just clears up the uncertainty. And we think that doesn't meet their obligation under the law. We also think the rule itself conflicts with federal law. It conflicts with the definition of a rifle, because it purports to redefine things that are not and cannot be rifles as rifles under federal law. And insofar as it does that, it conflicts with the federal statute.
A lot to go through there. So I can hear the keyboards clacking away. So let's start with the Second Amendment issue. And obviously, I mean, look, is there a way that people can read your brief in case they want to just really plunge into it?
Yeah, they can find all of our case documents on our website, will-law.org. You can find our open cases there, and everything's posted on there. So we filed this lawsuit a couple of weeks ago. Last week, we moved for what's called a preliminary injunction. We're asking the court to set the rule aside while the merits of the underlying legal issue are litigated.
So last week being first week of February, that's when you've asked for the preliminary injunction. And we're going to keep going to the list of all the other great things you mentioned, but that's going to be super important, asking for that injunction. Yes. So let's actually tease that. We'll get back to that in a moment, all right? So what are some of these constitutionality issues that you're looking at? How do you feel like the ATF has violated the Second Amendment?
Yeah, so just last year, the U.S. Supreme Court handed down a decision, New York State Pistol and Rifle versus Bruin. In that case, the Supreme Court struck down some regulations that violated the Second Amendment. And in doing so, they said that whenever federal agencies are attempting to regulate firearms, that the Second Amendment is triggered. It's an individual right that you have to possess a firearm. And when they do that, they have to look at the historical regulation of firearms, and they have to explain why the tradition and the history of firearm regulation supports their regulation. ATF didn't do that for this regulation. They simply said, no, pistols with a stabilizing brace are short-barreled rifles. Short-barreled rifles have been regulated, therefore we don't have to worry about going through that analysis. But that's wrong. They missed the step. They have to explain why pistols with stabilizing braces have historically and traditionally been regulated as a firearm under the NFA, and they simply can't do that. So our legal argument is that violates the Second Amendment. It violates what the court said in Bruin, and it should be set aside.
So kind of to that point, and I'm going to play devil's advocate, and we can take that term however literally you want down the lens. But I'm going to play devil's advocate here because we all know what they're going to argue, right? Mm-hmm. They're going to say, look, these devices were just invented in 2012 or thereabouts. So anytime we're looking at an emerging technology, an emerging product, how do we say that it's going to fit within a historical tradition regulation? What kind of arguments do you anticipate the ATF is going to be making? I mean, because that's obviously, do they have a fair point there that hey, you know, there can't be any historical regulations if it's a brand new product?
Yeah,
is that fair?
Yeah, I mean, I think it's. I think the Supreme Court, rightfully so, set a very exceedingly high bar for federal agencies to meet. And it's because, again, this is an individual right that's guaranteed by our Constitution. Nothing can be more important than that, right? So it's, yes, I think it's a high bar that ATF has to meet. I think there's going to be litigation like this and others that's already coming out that is trying to find the outer limits of that and apply that exactly as you had said. I think in this case, though, what ATF's primary argument is going to be is that they just don't have to do that analysis. I mean, they kind of take the position, as I said, that these are short-barreled rifles. Short-barreled rifles have historically and traditionally been regulated for the past, almost 100 years, not quite, under federal law. So they say, this meets it, and that I'm assuming is probably going to be what they argue. But, we'll know more in a couple of weeks when they file their response to our preliminary injunction brief.
About what date do you anticipate to have the response?
I would have to look that up, but it was 21 days from when we filed it, so about 2 weeks from today.
Okay, so we're talking down the back half of February, pushing March, give or take.
Late February.
Okay. So that's when we can kind of anticipate to see those. And just to parse your answer a little bit, but I want to make sure I'm doing so fairly. So what you and Will, Wisconsin Institute for Law and Liberty, are anticipating to see from the ATF is, look, obviously pistol braces are brand new, but it's a similar product to what has been regulated historically. Now, of course, there's going to be a huge discussion as to whether or not the National Firearms Act of 1934 is inside or outside of our nation's firearm tradition. I think that the U.S. Supreme Court has done some things to kind of pull that in, unfortunately, vis-a-vis referencing it in some of their decisions. So whether directly or indirectly. So I feel like that's going to wind up being their argument of, look, this is a close analogy, or as one court we saw in the District Court of Oklahoma, Western District Court of Oklahoma, when they were kind of parsing the Second Amendment issue, they said, well, look, this falls within the sphere, okay?
Yeah, I think part of what ATF's position here is going to be is that a pistol brace is just nothing more than a shoulder stock. That's going to be their primary argument. So that, this particular device was invented in the past 10 years or so, give or take, and became into heavy use over the past decade. But really, it's just a stock, and it's just a stock by another name. And stocks have historically been, regulated, or at least not the stock itself, but associated with a rifle. And that's kind of how they'll try to get there, I assume. But again, it's a little too early for me to be able to say one way or another, except based on what we've seen in their rulemaking document, which is a couple hundred pages long. And they try to set this stuff out. But the primary argument they made in there for why they don't have to do the Bruin analysis is just because they say these are SBRs. SBRs have historically and traditionally been regulated. Therefore, they're dangerous weapons, I think they call them, and dangerous weapons don't fall under the Second Amendment.
Guys, really briefly, if you're enjoying this interview, please show your support for the Second Amendment, for the Wisconsin Institute for Law and Liberty, Attorney Lucas Weber, as well as this channel by clicking like, sharing it around social media, clicking subscribe, and commenting below what you think about the video. On with the show. One thing I want to touch on that I know folks are going to be really curious to hear, and you actually kind of brought it up in your response there, was just how common these weapons are. right?
Absolutely.
I mean, because obviously, as you know, the Congressional Research Office, I mean, you cited it earlier on, has estimated there's between 10 million to 40 million devices that are out there in circulation. They're in interstate commerce, right?
Yeah.
To use the legal language we all love to use, right? So one of the tests that Brune has talked about is, well, when we're talking about weapons regulation, we're talking about historical tradition, but we're also talking about how much they are in common use. How much do you think this could play a role? The fact that it's not like there's 1,000 of these devices or 500 of these devices, or like bump stocks, 500,000. There's millions and millions. I mean, lowest estimate 10 million, highest estimate 40 million. I mean,
Yeah.
do you see this playing a role, and if so, how?
Yeah, sure. So in the rulemaking documents, ATF makes their own estimates too. They estimate between 3 and 8 million, and then they say without really much evidence that it's closer to 3 million. But still, we're talking in the millions. Congress's research service says 10 to 40. So somewhere in the range of 3 to 40 million is, no matter where you are on that spectrum, a significant number of these braces out there in commerce, as you said. I think that the fact that there are this many that exist, and the rulemaking documents cite to 2 incidents. They say there have been 2 shootings using a short barrel rifle, a pistol with a brace they call a short barrel rifle. Of the millions that are out there, I think their ATF is going to have a very difficult time pointing to the existence of a pistol brace as the reason for that, and that wouldn't have happened but for the pistol brace. It's almost a silly argument for them to make, given the number of these devices that are out there, and they're commonplace now, and I think that will be a significant part of the lawsuit. It goes to the history and tradition, right? These firearms are ubiquitous; they are everywhere. These devices, and for ATF to now suddenly come in after years, and it's important to say that multiple times over the past decade, ATF has said these are perfectly legal. The attachment of a pistol brace to a pistol does not convert it into an NFA firearm. And now overnight, they've just changed their mind completely. And that's all going to be at play in this lawsuit.
And of course, something else that you brought up before was the ATF is claiming that somehow the fact that you have let's just call it a rifle for now, although I hate doing that. But at any rate, regardless of the overall length, regardless of the barrel length, somehow it becomes more lethal or more dangerous.
Exactly.
Can you speak to that at all?
Yeah, I mean, again, that kind of they attempt to sort of make that argument that this becomes a more dangerous weapon, which then in their minds makes it outside the scope of essentially Second Amendment review. But again, I don't think they've met their burden of showing that. I don't think they can meet their burden of showing that. Here you've got millions and millions of law-abiding Americans who own these devices, who use them every day without incident. It's simply ludicrous for ATF to argue that. They will, of course, argue that. I don't think that the argument is a good one. I don't think it's based in reality, and I don't think a judge is going to buy it.
And, my guess as to what's going to happen is they're going to point to the NFA saying, well, this is good. You can't argue with this, and this is close to that. How much do you see playing a role? And again, I appreciate the fact that this is an ongoing lawsuit. You may not want to tip your hand on everything. So if you prefer to say, we'll have to see how it plays out, I think both myself and the folks watching will understand that. But of course, the original drafting of the National Firearms Act, we're talking about machine guns, we're talking about short barrel rifles, we're talking about short barrel shotguns, we're talking about just a range of what we now call Title II National Firearms Act, NFA weapons, right? But something that a lot of people don't know is within the original scope of the NFA, we're talking about all handguns. And that's actually how the NRA largely came to prominence, was fighting that inclusion of handguns. Do you see that little bit of borderline secret knowledge out there that the National Firearms Act almost included handguns, and the fact that the U.S. Supreme Court in New York Rifle State Pistol Association v. Brune explicitly went out of their way to bless handguns as being an ordinary constitutionally protected weapon, yet that was the whole focus of the NFA at drafting. Do you see that coming up in this lawsuit?
Absolutely. I think the statutory history of the NFA is going to be heavily scrutinized in this lawsuit. I think it needs to be, and I think it's very enlightening along the lines of what you've said as to what Congress actually intended here. And some way that gets to our second claim of the second constitutional claim as to who gets to write laws and it sort of is under that umbrella in our suit.
So let's go into that. So, of course, what we're talking about here is rulemaking, right? Because the ATF, although they may think they can write laws, but they can't. They're a federal agency. They can write rules. Rules are not laws. These are different. Rules are interpretations of the law, right? Congress will do kind of big picture stuff, and then agencies step in to fill the gaps. But they can step in to fill the gaps without creating new gaps, without creating new lines and so forth. Is that a fair way to understand what we're talking about here?
Yeah, I think so. I mean, I think most people understand that, we see the Schoolhouse Rock video and we learn about it in 4th grade. We know that Congress writes the laws, the president enforces the laws, the judiciary interprets the laws, but there's also this federal bureaucracy that's kind of the fourth branch that's out there that takes these laws that are written and decides to just kind of write some more on top of it. They, in many cases, in all cases, have essentially the same force and effect of law. You're bound to abide by them, or you could be subject to penalties under them. But they're not written by elected officials. They're written by agency bureaucrats, people who have never stood for election, people who no one's probably ever even going to meet or know who they are, and they're accountable to essentially to no one. Congress has some limited oversight powers, but it requires a rather Herculean effort for Congress to get involved and to overturn these rules.
I'm going to go out on a limb and just guess that this is not the first time you've dealt with bureaucrats writing laws by fiat. Is that fair?
Absolutely not. And it's something that our firm takes on almost every day at both the state and federal level. It's all too often, right? Our United States Constitution, excuse me for getting on a soapbox quick, but our Constitution was designed to protect liberty through the structural limitations on government power, right? So when our founders set up our Constitution, the first line of defense, the first line of protecting liberty was to make sure that government never had the power to take away your liberty. And the way they did that was they created the separation of powers, structural limits that said, you can't do X, Y, and Z. You can only do A, B, C. And if you ever do X, Y, and Z, this other branch gets to step in and tell you that you've gone too far. After the Constitution was adopted, we then adopted the Bill of Rights, which further emphasized and protected those rights. But it's really those structural limits that protect individual liberty first and foremost. And, one of those structural limits is that Congress writes laws. Now, courts have, in my opinion, gone way too far and allowed them to delegate that power to these unelected bureaucrats for too often. But we see in this case, ATF has essentially just completely rewritten federal law. So Congress has said in the NFA and in the Gun Control Act that they're going to regulate rifles. And rifles with barrels less than 16 inches could be could be subject to the NFA. But a rifle is defined as a firearm that's designed, made, and intended to be fired from the shoulder. So you have to meet all three of those requirements. What ATF has basically said is, we're just gonna say here on a whim that we think you actually are intending for these to be, whether you designed them or made them, we think you did because we want to regulate them. So we're going to imply that with a rule and hold you criminally liable if you don't register your firearm.
So what ATF, of course, did, among many things, is they even took screenshots of people on YouTube and demonstrating how that you can use pistol braces, to fire it from the shoulder, mm-hmm. right? What kind of role, if any, do you think that's going to play in this case? The fact that I realized that in 2012 they approved the original SB Tactical Brace as being good to go, designed to be fired not from the shoulder. In 2014, they issued a new ruling saying, yep, it's okay. It doesn't change the classification and the regulation of the pistol into a rifle if you do fire it from the shoulder. Do you see those rulings as playing any role? Does that hold water in court, or do they just get to play oops takebacks on that?
Yeah, I think it does under as I said earlier in our discussion, the Federal Administrative Procedures Act has provisions that essentially agencies can't take arbitrary and capricious actions. Agency action can be arbitrary and capricious if they just kind of willy-nilly reverse themselves on a long-standing, something they've held a position and now they just have a different position. Now, certainly agencies are allowed to change their position, but there are steps they have to go through. As I said, they have to acknowledge that they're actually changing the position. I don't think ATF has done that here. I mean, they've certainly acknowledged that they've approved pistol braces before, but they've said it in a confusing way of, well, we've sometimes approved them, but we also have not really approved them. So what we need to do is adopt this rule to give some clarity to everyone, is how they kind of frame things up in their rulemaking document. So what they say in the rule, then they kind of create this two-step process for determining whether a pistol with a stabilizing brace is an SBR. The first step is they look if there's any surface area on the back of the weapon. They don't define surface area. It's very confusing. I don't really know what that could be, if it's the buffer tube, if it's there's no, anything could be surface area. All guns have a surface area right on the back of them. So once they determine they have that, which I think pretty much any firearm would have one, they go on to the next step, which is analyzing whether under a 5-step analysis, there are things that make it seem like they were designed, made, and intended to be fired from the shoulder. So in there, they look at things what they call indirect marketing material, which could be some of the stuff if a firearms manufacturer puts something out online, I suppose that's what they'd be looking at. But they also say information how the weapon is intended to be used generally in the community, which is just a silly, nonsensical regulatory position to take. It's a catch-all, right? They just get to say, oh no, I mean we saw some Reddit message board where some guy said he's going to use this to fire from the shoulder. Therefore, everybody who has this, regardless if you saw that or not, suddenly is subject to it. Now, many people have built their own pistols and attached their own stabilizing brace to it. And what ATF purports to do is just import and imply intent on all of these people based on what they've seen on some websites with somebody that these people may have never seen, may have never met, might not even know they exist. So
it gets super confusing.
Absolutely.
Right, because it doesn't matter necessarily at all how you are using it or how you intend to use it. They're looking at the whole community and then imputing that on you.
Exactly.
Do you think there's any legal weight to that? Are they allowed to look at how, I mean, forget pistol braces, just whatever device. They approve a device as being lawful, not an NFA, nothing like that. And suddenly the community kind of zigs instead of zags. Is that permissible, or is it an issue of once they've opened up the barn door, hey, that's on them, they should have foreseen all that as part of their regulatory approval process?
Yeah, I mean, I think it does. Obviously, there's reliance interests there when, you've got up to 40 million of these in the public. Those are things that the agency has to consider when they go through the regulatory process. Now, ATF's rule purports to do that. They kind of pay it lip service in their rule and try to check the box. But again, I think that what ATF has done, besides the constitutional issues, violates some of these statutory provisions of the Administrative Procedures Act, which is just another legal claim against it.
This is amazing. I mean, you can interview yourself. This is so that gets us to the statutory issue claims that I wrote down. So briefly, what are we talking about here?
Yeah, so again, there's a federal law called the Administrative Procedures Act. It sets forth the rulemaking procedures that agencies have to follow. So again, this is legislative power under our separation of powers. The courts have allowed agencies to be delegated some of the power to sort of write these, they're not laws, but write rules that have sort of the same effect of law, as long as they do so subject to strict the requirements that Congress sets forth. So Congress has to give them some idea of what to go on, essentially, and then a process they have to follow. So our lawsuit also, beyond the constitutional arguments, argues that the rule itself violates the Administrative Procedures Act in two primary ways. The first, as I said, is that it's arbitrary and capricious. It's a reversal of their prior decision in a way that they simply haven't supported. And second, it violates, it conflicts with federal law because it purports to regulate as rifles things that are not and were not intended to be rifles. So our clients, for example, did not design, intend, or make a pistol to be fired from the shoulder. And if they, I mean, that's plain as day. There's no dispute that they didn't. But ATF now says, no, they actually did because we look at it purely from our perspective and say that they did, so we can change your intent overnight.
So you originally sketched out four ways, four kind of thrust what your lawsuit is. We dealt with the Second Amendment, that this is a violation of the Second Amendment. We talked about this as being an overstep of the delegated rulemaking authority. And of course, you and I can disagree with how much delegated ruling authority or they should have. But we're talking about the fact that, look, this is a clear overstep. And then we talked about statutory claims. Anything else that is the focus of the lawsuit here?
No, those are the primary ways that we are attacking it. So I think we raise all four. They're all sort of in the alternative, but the court could rule on all four of them. Courts generally tend to like to and have a preference for statutory claims. If they can avoid a constitutional claim, they'll rule on that. So kind of determine up to the court to determine if we win on any and which ones we'd win on. But we feel pretty confident about all of them. We think we've pled them well and we've explained them well, and they're all well within the case law and historical precedent.
So for folks who are curious, because I know that there's nerds out there who are going to say, why would a court prefer to rule on statutory? And I can make guesses based on my experience in criminal, i.e., it's just cleaner and simpler for them.
For sure.
Is that the same way?
Yeah, there's a judicial doctrine called constitutional avoidance, where judges will typically try to just avoid, if they can avoid deciding a constitutional issue, they will. If they can just do it on statutory grounds, it's not a requirement. It's not something that they necessarily have to do. Although courts will usually, if they can rule on a statutory issue and avoid reaching a constitutional claim, they always will do that.
Gotcha. So you mentioned before that you filed for an injunction last week, back in early February. Correct. What would that do if granted?
Yeah, so the rule itself is effective as soon as it was published, but it gave what they call 120 days of enforcement discretion. So ATF has said, hey, you can do one of several options to come into compliance, and we're not going to start enforcing this for up to 120 days or making you comply with it. So what we asked the court to do was, before that 120-day period is over, to set the rule aside while the underlying merits litigation plays out. So when you move for a preliminary injunction, you have to show a number of things. The most important one is that you're likely to win on the merits of the case. So it doesn't mean that you're going to win. The court just has to determine that there's some likelihood that you could win on this case. And if the court can determine that and determine that there's irreparable harm, there's other things, the public interest weighs in your favor, then the court can set the rule aside essentially temporarily while the lawsuit plays out, the underlying lawsuit. Many of the other factors for an injunction are essentially met when you have a constitutional issue like this. So it's a little bit of a different analysis. It essentially just comes down to the likelihood of success on the merits, although we argue all of them in our brief. But as a matter of law, what the PI would do was it would say that ATF has to set the rule aside, cannot enforce it at all, just presses the pause button while the litigation moves forward until the litigation is over.
If the judge does grant you the injunction, first off, when would that be? And secondly, would that only be valid for folks who live in the judicial district in Wisconsin that you filed, or would this be valid for folks nationwide?
Yeah, so our suit is filed in the Northern District of Texas. So we have plaintiffs in Texas. We have plaintiffs in Wisconsin. We brought the suit in Texas. In terms of how quickly the judge would issue it, don't know for sure. It's always up to a judge to make a determination as to whether or not the judge will grant it is entirely in their discretion. We would hope that a decision would come fairly quickly after it's been briefed. So, we filed our initial PI motion. The federal government will respond to it. I think it's 21 days, and then we'll file a reply to that within 14 days, and then it'll be fully briefed. It'll be up to the court if they want to hear argument on that. The court could have us all come in and argue the motion in person, and then the court will make a decision on it. As to its applicability and how broad it would be, again, that's up to the court as to how far they want to extend it. Is it just going to apply to the states where our plaintiffs are from? Is it going to apply broader? That's actually a really interesting question under constitutional law, legal, administrative procedure nerds throughout the country as to whether courts can issue a nationwide injunction on a rulemaking case like that. And I think it's something that will probably come up in this case.
Is there any precedent for judges to do just that?
Sure, definitely. Yeah. So you see things like when OSHA had the vaccine mandate rule back then, and when they set that rule aside, I think there certainly is precedent and precedent on both sides of it. So it's something that is kind of, I guess, an unsettled area of the law, we'll say right now, but something that is TBD.
How long is this? And I realize this is an impossible question, but as somebody who gets asked impossible questions all the time, it's fun for me to be the one asking them. So how long is it going to take from now, so we're talking middle of February is when we're recording this, how long from now is it going to take, do you think, until this case has resolved one way or the other?
Complete resolution all the way through the courts. I think, depending on what happens on the preliminary injunction motion, if we win or we lose, or if, the government, there could be an appeal after that on the decision to grant or not grant a preliminary injunction motion. That appeal could potentially go, or it would go to the U.S. Court of Appeals, and then it could potentially go to the U.S. Supreme Court. Obviously, they don't have to take the appeal. They could decline to, but that would itself take probably through the end of the year, certainly into the fall. We're talking at the very least, and if the U.S. Supreme Court grants it, it could be into next year. Then, depending on what happens with the preliminary injunction, then the case would go back to the district court and for a merits decision, the underlying merits decision. And obviously, the outcome of the preliminary injunction proceedings will have a significant impact on the merits decision and could, in fact, be determinative itself. In many cases, that happens.
So I just want to put this into English to make sure that I'm getting it, because again, my background is, as you know, as a former state prosecutor, criminal defense attorney. That's my realm. So I can follow you on the constitutionality stuff. I can follow you on a lot of the procedure stuff, but then we get to some of these nitpicky civil things, and that's where my eyes start to gloss over. So I know if I'm losing you, folks might be losing you. So what you're saying is that, okay, so step one is the court will determine whether or not they're going to grant injunctive relief, i.e. are they going to press pause, and if so, what's the scope of that pause? That will be the first moment where either side can then appeal that to, I think it might be the Fifth Circuit Court of Appeals.
Correct.
Down there.
Yep, it's the Fifth Circuit.
Okay, so that's kind of step one, where in other words, the lawsuit gets put on hold, it goes up to the Fifth Circuit, potentially all the way to U.S. Supreme Court, and then based on how that turned out, and of course, I can imagine the rigorous constitutionality treatment of the issues in play, that may do a lot to shape how the case returns. Because I think what a lot of people get wrong, and I want to make sure people understand this, is, so let's say this goes up in the constitutionality merits to the Fifth Circuit and the U.S. Supreme Court. The U.S. Supreme Court and the Fifth Circuit make some rulings, whatever they do. It's not like the case is necessarily done.
Correct.
Right?
Yeah, it would come back, and the preliminary injunction is just that. It's preliminary relief while the case pens, essentially. So, if we, for example, if the judge was to deny our preliminary injunction motion, we would, presumably very quickly try to appeal to the Fifth Circuit. We would ask them to decide it very quickly, because we're under this 120-day window, wherein if that period ends, there's no putting the cat back in the bag, right? Because our clients and potentially millions of other Americans would be subject to the requirements of this rule. And so we would ask for hopefully some relief, before the 120 days to be completely to have some answer by then. But as you said, once the preliminary injunction stuff is kind of done, and that could go all the way to the U.S. Supreme Court. Once that's all done, the case itself comes back to the district court level, the trial court level, and they say, okay, now we've determined that the preliminary injunction is going to press pause on the rule. Will we move forward? How are we going to go forward on this rule? And there could be anything from more motions, more briefings, potentially a trial. There aren't really questions of fact here that a jury would weigh, but that's kind of when that process would go. So it's a very confusing and lengthy legal process, but I think for what most people are going to be interested in would be these preliminary injunction proceedings at the front end. So,
am I reading too much into it, or is it safe to say that how these preliminary injunctions play out may absolutely determine the long-term outcome of the case?
Yeah, absolutely. It certainly can. A court, for example, the U.S. Supreme Court could step in and say, no, plaintiffs, you are not likely to win on the merits because the law doesn't mean what you say it means, and here's what the law means. And then when we go back to the district court, we are just hamstrung, and there's really nothing we could do at that point because the court has told us what the law means, and our case is essentially over at that point, right? And it could have the reverse effect. They could come in and say, yes, you're likely to win on the merits of this case because you're 100% correct in what you're saying on all of this, and we will remand that back to the district court for proceedings consistent with this opinion, and then the government would be in the same position at the district court level.
So as an example, that if, for instance, goes up to Fifth Circuit, SCOTUS, U.S. Supreme Court says, yes, this is absolutely arbitrary and capricious. Yes, this is absolutely, this doesn't fit the definition of what is an SBR. So we now have these two kind of decisions made by a higher court. It would then get kicked down, hypothetically, back to the trial court. And now the trial court takes those two opinions, in our example too,
Yeah.
and now that is like from on the mountain, that is from the
Exactly.
gospel, and they are stuck with that. They can't modify that.
Exactly.
Okay, and that's how that could work either way, right?
Yep. Yeah, exactly. And that's how, in civil suits and in these types of area in constitutional law and things like that, that's typically how it works. I mean, it's a kind of a 10,000 foot overview that we're doing here, but that's typically how these types of suits play out. There's usually a litigant will file a suit. They'll seek a preliminary injunction. There'll be some back and forth on the preliminary injunction, and then a higher court usually weighs in and makes a determination on that, which then impacts the underlying suit itself.
Right. And I think that that's really important and relevant for folks to understand how this stuff works, because you look, if you're in the Second Amendment space, I mean, we're used to having suppressing fire put down on us from courts and agencies and all this other kind of stuff. But most people don't really understand how this all kind of plays out in reality. So I think that that's extraordinarily helpful to hear that. So again, if you don't have a comment, that's totally fair. Your lawsuit is not the only lawsuit that's out there. There's a number of other lawsuits. Do you have a sense for, is everybody doing more or less the same thing? Are there some discrepancies between lawsuits? And obviously, it's not reasonable for you to know every single in and out of every single lawsuit, but I didn't know if you just had an off-the-cuff reaction to that.
Yeah, I think there are a number of suits. I've read many of them. Certainly, I can't say definitively I've read all of them. Make similar arguments, but some different stuff. Some people make different APA claims, for example, or additional APA claims, or different constitutional claims. There's just sort of variations on the same underlying theme. But I think general underlying theme and the relief that's sought, which is setting aside the rule, is a constant throughout all of those suits. So, I think at the end of the day, we're all kind of rowing in the same direction. I certainly can't speak to all of them out there, but, I think as a big picture, a big ticket item, they're all very similar.
All right, guys, last time I'm breaking in here. Thank you very much for sticking with us so far. There's a lot more great content coming up. Please show your support for not only this channel, but also the Second Amendment and the Institute for Law and Liberty. Click like, share this video around, click subscribe if you want to see us to be able to get more interviews like this one, and on with the show. Is it possible for the ATF or somebody to ask for joinder to combine all these into a single jurisdiction? Because if they're all similar enough, judicial economy, decision, all that kind of stuff, let's just hear them all at once, right?
Possibly. I don't, again, having not read kind of all of them, I don't know what the likelihood of that would be. But certainly, I guess, is it possible? Yes. Is it likely? I don't know the answer to that. So.
Who would be the attorneys representing the ATF? Do they have their own attorneys? Does the Justice Department step in?
It's the United States Department of Justice. So these are assistant U.S. attorneys who will be representing ATF in our suit, defending the rule essentially, and they're all assigned by either the local assistant U.S. attorneys in these districts or national. They have a national litigation team as well, and I can't say specifically who's going to each one, but they'll all be U.S. DOJ attorneys.
So as somebody who works in this space of, suing government, I mean, that's what you do, right?
Every day.
How much does a role, if any, do elections play as far as, the head of the ATF, the head of many of these agencies, these are political appointees by presidents and maybe governors at state levels and so forth. How much of a role, if any, do elections play as far as, yes, you guys see major turnaround as far as policies, enforcement procedures, and so on from an election to an election with changing results?
Yeah, I mean, tremendously. These, as you said, these are political appointees, right? So at the end of the day, kind of the buck stops with the president. Agencies are somewhat limited, as I've been saying, in sort of what they can do to reverse themselves through the idea being, you want to have sort of a constant application of the law without kind of this knee-jerk back and forth sea change every time you get a new administration, although we are seeing more and more of that all the time. But yeah, I mean, elections matter. Elections to choose the executive branch matters because the executive branch puts all these appointees in who sign these rules at the end of the day and promulgate them on us.
Do you think that, so I imagine that in many of these agencies, maybe even the ATF I've heard, that there are folks who have a sane, level head about something, and do you have a sense, and again, maybe you don't, but do you have a sense as to whether or not a lot of times these folks are basically just being strong-armed by political appointees to do something? I was just watching The Sopranos yesterday night, and they're pitching this like farce stock, and like these gangsters come in and like beat the crap out of these salesmen, because the salesmen recognize this is like a stupid stock to be selling, but they're doing it because it's all part of like the mob scheme. I kind of see the same thing here. It's like, do you think people are like, yep, I'm on board. That's why I work at the ATF, because I believe in the regulation of the Second Amendment. I believe in gun control, or whatever the case may be. Or do you think this is like, there's a lot of people who are trying to work within the system to protect the Second Amendment somehow?
Yeah, so I certainly can't speak to every staffer at ATF. I mean, I know that.
Why not?
I think many people who work in government are committed to public service and do a good and important role. And I'm not trying to disparage them all, but there are certainly ideologues who want to use the heavy hand of government to push their personal agenda. This was certainly a hot button issue. Gun control always is. The current president, campaigned on it. He's delivered on his promise here with this rule in part. And I think there's, a lot to be said for this is being driven by, political ideology rather than what the law means. I think as evidence of that, we've seen, ATF for years repeatedly affirmed that stabilizing braces themselves do not convert a pistol into an NFA firearm. And now just overnight, the law means something different, only the law hasn't changed at all. The only people that have changed are the people who are at the head of the agency that, administers the law. So,
and it's maybe worth pointing out for those of you who aren't doing your math correctly, but those initial stabilizing brace rules where the ATF came out and said, yep, not an SBR, those came from under the President Obama administration.
Correct.
In 2012 and 2014.
Yep.
So this isn't a matter of playing political football back and forth. Well, President Trump said this, and now President Biden said that, and hey, them's the breaks, kid, right?
Exactly, yeah.
This actually came out from the President Biden administration, who blessed this twice.
President Obama, yeah, correct.
Right.
Yep. So that, it's something that I think the law means what it means, right? I mean, it's sort of, it's been written, it's been, a long time on the books, decades, the law has been on the books. The law doesn't change, so how can the law suddenly be expanded to cover an additional 40 million firearms under it overnight? That gets to, again, the underlying claims in our lawsuit that ATF bureaucrats don't get to write laws. They don't get to redefine federal law to expand its scope. I think there were, I don't know what the exact number is, but less than 500,000 SBRs registered prior to this rule. If the 40 million number is correct, we're talking about just an astronomical increase in how many are regulated by this agency, all without a single vote of Congress changing the law. That can't be our system of government. It's not our system of government. It's beyond the structural limitations of government, and it is infringing on individual liberty, which is why I think suits like this and the others that have been filed are so important.
Yeah, I mean, it's almost an 80x increase just at a stroke of a bureaucratic pen.
Yeah, it's wild.
So you mentioned you have a handful of plaintiffs here.
We do.
People know that there can be a process for the selection of plaintiffs, whether you're on the right, you're on the left, wherever you might be,
yep,
as well as a careful selection of the forum about where you're going to bring a lawsuit. Can you speak to that at all? And maybe if not about this case, because again, I understand this is ongoing litigation, but can you speak to how, regardless of your political stripe, how this process plays itself out? Because I think a lot of people are curious about that.
Sure, yeah. So as an organization, us and I'm sure many other public interest law centers like us do it the same way. We have essentially two ways that we bring up cases. The first is we have a form on our website. You can contact a lawyer. If government is infringing on your rights, you can fill out the form and contact us. And we'll have attorneys each week. One of our attorneys is assigned to review all those and see if there's something that we can take on and fight for.
And just as a heads up, that link will be in the description box below if you're curious.
Absolutely. And the other way we do it is for other lawsuits, if there's something we kind of develop on our own, we say, hey, here's an area where the government is overreaching. Do we have a plaintiff who would be interested in challenging that? And we talk to individuals there. Obviously, in terms of venue, we're limited to where our plaintiffs reside. So in most cases anyways, or where the incident occurred. But so we're a little more limited there. But yeah, just always We are always looking for individuals who want to stand on the side of angels here and push back against government overreach. And, we're a nonpartisan organization. I've represented Democrats, Republicans, nonpartisan people, and will happily do so in any case. Certainly, Liberty knows no party or no political ideology, but we love to talk to people when the government's stepping on their toes and about their rights and how they can fight back, and those cases are a heck of a lot of fun to develop.
And what kind of plaintiffs I realize it probably varies from issue to issue, but you're probably looking for somebody who's going to be able to stand up to media scrutiny. They put a good face on something, so to speak.
Yeah, definitely. I think, a lot of when you become a plaintiff in these types of suits, you essentially become a public figure. People are going to want to talk to you. They're going to dive into your past and maybe what you've done, and they're going to want to talk about that in some cases. So yeah, we always want to talk with our clients on these types of cases. Public interest cases are typically different than a private litigation case. There's a lot more media scrutiny, and our clients do interviews. They'll talk to media. I think most lawyers will say to their clients, like, do not talk to the media, do not go on camera, do not do that stuff.
I can confirm that.
I think, though, for us, it's different. These typically the facts aren't really in dispute in these types of cases. There aren't factual matters that sort of we're going to need to determine. These are just, everybody kind of agrees this is what the facts are. The question is just, how does the law apply? And that's I think a similar what we're seeing in this particular lawsuit. Again, it's just our three plaintiffs here are three plaintiffs who own pistols with stabilizing braces. Because they own pistols with stabilizing braces, they're necessarily subject to the rule and have to go through that determination process, and could be subject to again, criminal penalties if their pistols are determined to be SBRs and they weren't properly registered, or they didn't remove the brace, or some of the other compliance measures that the rule has.
You file this lawsuit. Are you going to win?
Yes. No, certainly can't guarantee an outcome, but and never would. But I think we, again, as I said, I think the case law is on our side, the precedent's on our side. I think we put together a very good case, and I hope that the justice system confirms that for us at the end of the day.
What do you want to put out there, or what gaps have I left that you think it's important that folks know?
I think it's just pay attention to what's going on and coming out of these agencies. This rulemaking document was a 300-page document. It's published in the Federal Register. I think most people don't realize that every single day our government, sometimes multiple times a day, our federal government is publishing an administrative register. Same at the state level. There's a weekly administrative register here in Wisconsin, for example, that tells you what all these agencies are up to. And they're writing laws, and these laws affect your life. In the forms of rules, and they affect your life, and they could force you to do things that you don't want to do, and you might not be required to do them. They could be unlawful, and without everyday Americans who are paying attention and willing to stand up and fight back, nobody's going to be able to stop them.
I have so many questions about suing government at all sorts of different levels. This is, like those medieval maps where like they don't know what's over there, so they have like a dragon going in and out of the water. Like that's kind of what this is to me. Folks, if you want to see us bring Attorney Lucas Weber back to ask these sorts of questions and just kind of go through lawsuits about where are we more likely to lose our rights at the federal, the local level, just more details about this, let us know in the comment field below if you want to see him back. Don't forget to support Will. How do you support Wisconsin Institute for Law and Liberty? How do folks get involved?
Yeah, thank you. We are a 501c3 nonpartisan nonprofit organization. Donations to us are tax deductible. You can make donations on our website at will-law.org.
And we'll have that link in the description box below. Lucas, thanks for coming joining us.
Thank you for having me.
I hope you all enjoyed this conversation. I found it to be so incredibly fascinating that I completely lost track of time. I thought we were about 30 minutes into this. There are no clocks in this room or anything like that. Maybe there should be. We just completely lost track of time. And then when we cut off the cameras, I asked Derek how long it was, and I was stunned at the outcome. So hopefully you guys liked it too. If you haven't already done so, you know what I'm going to ask you to do. Please click like, subscribe. Let us know in the comment field, what did you find the most interesting? Do you want us to see Attorney Lucas Weber back here? Do you want us to be following up on this case? Let us know in the comment field below. As always, we'll see you in the next one. And if you like this interview, and if you stuck around this long, I'm hoping that you did, here's 2 other interviews that you may also find interesting.